5 seconds to go. Start. After 2 rounds of litigation before the trial court and the High Court, it is fairly certain the case is to be examined only with respect to the offences under sections 364 and 302 of IPC, read with section 34 IPC. With respect to the offence under section 364 IPC, the case of the prosecution is based on direct oral evidence, and with respect to the offence under section 302 IPC, the case of the prosecution is essentially based on circumstantial evidence, as no direct evidence of the commission of murder could be collected. However, it is quite evident that the offence of murder was committed after the commission of the offence of abduction. There is a sequential relationship between the two offences, and thus, in order to set up a case for the commission of the offence of murder, it is necessary to prove the commission of the offence of abduction by the accused person's appellants. For the chain in a case based on circumstantial evidence must be complete and consistent. In order to prove the offence under section 364 IPC, the prosecution has relied upon the oral testimonies of 4 eyewitnesses, PW2, PW4, PW5 and PW18. Their testimonies have been assailed on various counts. The appellants have termed the said witnesses as interested and chance witnesses. The former charge originates from the fact that the witnesses were related to the deceased, and the later charge originates from the fact that the witnesses had no reason to be present at the place of offence, and they just appeared unexpectedly as a matter of chance. Let us examine both the aspects. We may first examine the testimonies of the witnesses independently without going into their relationship with the deceased. The informant PW18 has deposed that he was standing near a rickshaw outside his house and the deceased was sleeping inside the house. PW18 was standing along with 3 independent persons. The 7 accused persons came along with 15 other persons. A6 and A7 along with unknown persons first came to PW18 and took him away towards the well and confined him there. Thereafter, the remaining accused persons, along with other unknown assailants, entered the house wherein the deceased was sleeping. Interestingly, as per the version of the informant, the house was bolted from inside and was opened by a tenant, namely Kumud Ranjan Singh. The problem with the informant's version begins from this point itself. As per his version, the first eyewitnesses of the incident ought to have been Doman Tenti, Daso Mistry, Surdas and Kumud Ranjan Singh. One person, namely Surdas, was stated to be blind and thus he may be excluded. Nevertheless, the prosecution ought to have examined the 3 natural witnesses of the incident, namely Doman Tenti, Daso Mistry and Kumud Ranjan Singh. There is no explanation for non-examination of the natural eyewitnesses. The version becomes more doubtful when it is examined in light of his statement that he could not prevent the accused persons. Stop.